As we have been reporting, the Supreme Court of Canada has upheld Canada's anti-terrorism law. The ruling comes after the High Court deliberated on the legal definition of the law and whether it violates the Charter of Rights and Freedoms. James Fitzmaurice is at the Supreme Courthouse, and he joins us now with all the details. So just take us through the decision here, James. What did the Supreme Court say?
Well, the real question here is whether or not the definition of terrorism was constitutional or not. Did it infringe on people's right to freedom of expression, freedom of religion, freedom of association, and the like? And the Supreme Court has found that, indeed, it does not infringe on any of those rights. At the nut of it, it says that your right to freedom of expression does not cover violent acts. You can't punch someone in the face and say, I'm just expressing myself. Similarly, you cannot commit these kinds of acts and say that they're part of your political or religious expressions. And by rejecting that argument, the Supreme Court has found that the definition of terrorism is constitutional. Therefore, the government's act, its anti-terrorism act, also withstands a constitutional challenge. And this is relevant, not just because of the stigma, which is part of the punishment, but also when it comes to sentencing, that the sentencing is more harsh under the Anti-Terrorism Act. In the case of Momin Khawaja, he was sentenced to life in prison for part of the crime, and the other part, which were somewhat lesser offenses, 2 years for this, 3 years for that. The law allows those sentences to be served consecutively, so they added up to 24 years in the end, which adds to this as well. The court had a couple of small caveats, warnings for police and the government for down the road, saying that it believes that this law should be interpreted very narrowly to only deal with violent acts. There is language in there that some have argued could make, say, a picket line in front of a hospital be considered an act of terrorism. The court signaling that it would reject such a case if it were to be brought forward later. It also says while this does not infringe on someone's freedom of expression and religion to be a part of a group, it warns police not to use that as carte blanche to start racial or religious profiling in its investigations. Similarly, when it comes to the sentencing, while it says in this case a very harsh sentence was appropriate, it says it is not automatic that in all future anti-terrorism cases that a harsh sentence is necessary.
And this is a unanimous decision, and the court seems very, very clear in its interpretation of things. Ultimately, what is the message being sent here, James?
It is, as you say, it is very clear. It is unanimous. There is strong language rejecting the arguments that were put forward, calling some of them irrational, lacking an air of reality, and even disingenuous. So the court is strongly endorsing the government's anti-terrorism legislation, acknowledging that it is an important aspect, that it is a crime that deserves special attention. It's not simply the act of setting off a bomb, but it's of setting off a bomb with a political message, that the sentencing and the law prosecuting that person should also send a message.